All right, let's get right into it. The law of sexual harassment. You know, it feels like this has always been a part of our work lives, right? But the truth is, the laws that protect people, they have a surprisingly recent and pretty fiery history.
So, where does this whole story begin? Well, it starts back in 1964. The Civil Rights Act comes along and prohibits sex discrimination. Huge, right? But it said absolutely nothing about sexual harassment. It just wasn't in there. So when people started coming forward arguing that harassment is a form of sex discrimination, the courts, well, they were really slow to get on board.
So how do we get from total silence in the law to where we are today? Let's trace that journey. It's a fascinating legal evolution.
Okay, so here are the big moments you need to know. After that 1964 Civil Rights Act, things were quiet for a while. It actually took until 1980 for the EEOC, that's the Equal Employment Opportunity Commission, to issue the first real guidelines defining harassment. But the real earthquake, that came in 1986. A huge Supreme Court decision finally locked this into law.
And to really get how massive that shift was, you have to see what they were up against. Just listen to this quote from an actual court ruling back in the 70s. It is, wow, it's jarring. It just shows you how tough it was for victims to get anyone to listen. Judges were basically saying this wasn't about the workplace, it was just some private, personal issue.
Okay, so once the legal groundwork was finally laid, the next step was to define what sexual harassment actually is. And in the eyes of the law, it really boils down to two main types.
So here they are. Side by side, you've got quid pro quo. That's just Latin for this, for that, and it's all about a direct trade. And then you have hostile work environment, which is totally different. It's about the vibe, the atmosphere of the workplace itself. They cover really different situations, but make no mistake, both are absolutely illegal. Let's start with quid pro quo. This is the most straightforward, blatant kind of harassment. It's when a boss or someone with power says, do this for me and you'll get that promotion. Or even worse, or you're fired. It's so serious that just one time, one single incident can be enough to bring a lawsuit.
Now, the second type, which is honestly way more common, is the hostile work environment. This isn't about a this for that deal at all. This is about behavior that's so bad, so offensive, or so intimidating that it just poisons the workplace. It fundamentally changes your job and makes it nearly impossible to get your work done.
And this can look like a lot of different things, right? We're talking about everything from unwelcome advances and non-stop offensive jokes to hostile emails or even stuff on the walls, like gross graffiti or nude calendars. The absolute key here is that the behavior is unwelcome.
But, and this is a really important but, the Supreme Court has been super clear about something. The law isn't meant to be a general civility code. It's not there to police every single rude comment. For something to cross the line and become illegal, it has to be either severe, like one really bad incident, or pervasive, meaning it happens over and over and over again.
So how does a court decide what's severe or pervasive? Well, that's interesting because the standard for judging it has actually changed over time. It used to be this vague, reasonable person test, but the problem was that perspective was often a reasonable man's perspective. So now the standard is much more specific. What would a reasonable person in the victim's position think? It takes their specific experiences into account.
Okay, so this all leads to a huge question. When harassment happens, who's on the hook? Is it just the person doing the harassing, or does the whole company have to answer for it?
And this is so important to understand. Under federal law, the liability, the legal responsibility almost always falls on the employer. The company itself is held responsible for what its employees do. Why? Because it's their job to provide a safe workplace.
Now it gets a little specific. If a supervisor harasses someone and that person gets fired or demoted, the company is automatically liable. Period. But if no job action like that happens, the company can try to defend itself. But to do that, they have to prove two things. One, that they took reasonable care to prevent it, had a policy, had training, and two, that the employee unreasonably failed to report it or use the system they had in place.
So what about when it's a coworker doing the harassing, not a boss? The rule is a little different then. The employer is on the hook if they knew or should have known about it and then didn't do anything to stop it. They can't just plead ignorance if the writing was on the wall. They have a duty to act.
Okay, so we've been talking a lot about the US framework, but this is obviously a global issue. And how other countries handle it? Well, it's really different.
Let's do a quick trip around the world to see. First stop, Brazil. There, quid pro quo harassment isn't just a workplace issue that could get you sued, it's an actual crime. A manager who does this could face 1 to 2 years in prison. Think about that. Now, let's go to India. The perspective there is totally different. The Supreme Court has defined sexual harassment as a form of violence against women. That framing puts a huge proactive duty on employers to actively prevent it before it ever starts.
And you see a similar theme in Japan, where the law puts that same kind of proactive duty on employers. They're legally required to have policies, to educate everyone, and to have a real system in place for complaints.
All right, so for our final section, let's bring it back to the US and talk about the bottom line. If a victim wins their case, what happens next? What are the remedies?
Under federal law, Title VII, there's a cap, and that cap on damages for things like emotional distress is $300,000. That's the absolute max under federal law, though the exact amount depends on how big the company is. So you might be thinking, okay, 300 grand, a big company can handle that. But is that really the end of the story? Is that the absolute limit?
And the answer is a huge no, because that federal law isn't the only game in town. Victims can also sue under state laws, and those laws are often way more powerful for plaintiffs. A lot of states have no cap at all on damages, which means jury awards can go way, way higher. So when you think about it, we've gone from a court dismissing this as just a personal urge to a full-blown global legal movement. The trend couldn't be clearer. Around the world, what was once something people suffered in silence is now being seen for exactly what it is: a basic, fundamental right to work in a place that's safe and respectful.